Let's bring in now Raymond Murphy. He's a human rights lawyer and professor of law at the University of Galway, and he joins us now from Galway in Ireland. Great to have you with us. We just heard from our correspondent in The Hague that this is an exceptional and unprecedented case. But how strong is Nicaragua's argument?
This is a very important case, and it seeks to clarify certain legal issues. I think it has made a strong case in respect of certain of the provisional measures that it is seeking, but I'm not certain that other measures it has claimed that the court should award will be successful. And at the heart of this case, there are two legal issues, and I won't be over technical. The first is, what exactly does it mean, the obligation to prevent and to punish the crime of genocide? And what exactly are the obligations that follow from the Geneva Conventions and Common Article 1, which requires all states to respect and ensure respect for international humanitarian law? And they're the two primary legal foundations on which this case is made. And it has great relevance not just for Gaza, but also for all states that manufacture weapons and supply states and other parties with weapons that are ultimately used to commit violations of international law, human rights law, violations of the Convention Against Genocide, and a whole host of other international measures that seek to protect civilian and other vulnerable groups. I think it also, Nicaragua did address one of the central weaknesses in their own case, and that's a technical concept known as the indispensable third party issue. Israel is not a party to this particular case, but it is central to the arguments being made. In other words, there's an accusation that Israel is committing violations of international humanitarian law and committing genocide in Gaza. And usually they would have to be a party to the case before this could proceed. But as was rightly pointed out, I think, by the representatives for Nicaragua, we can't wait to prove that genocide is occurring. We're all on public notice, and all states are on public notice, that there are serious violations of international humanitarian law, and the International Court of Justice has already established that there is a plausible case to be made to protect the civilians of Gaza from genocide. So there is a lot of merit in the case. There are a lot of political and legal implications for this case. And what does surprise me is, unlike the case taken by South Africa, how little public attention and international media attention has been given to this case.
Because if I can just jump in there, Raymond, much of what the court is covering today, I mean, it's uncharted territory, isn't it? So this is a case that really could strengthen international law.
It is, and for that we owe a debt of gratitude to Nicaragua. If we get clarification on exactly what it means, what are the states' obligations, all states' obligations, to prevent the crime of genocide, and what are the legal implications for Germany and other states that are providing weapons to Israel, now that they are aware that there's a plausible case for genocide and that there's overwhelming evidence of a range of serious violations of international humanitarian law. Viewers might wonder, why did they not take the case against the United States, seeing as the United States is the primary supplier of weapons to Israel? The reason is simple, in that the United States has opted out of the relevant clause within the statute of the International Court of Justice and also the Genocide Convention that would allow such a case to be taken against it, whereas Germany has not done so.
OK. Raymond Murphy, many thanks indeed for bringing your expertise as we open that first day of the case against Germany brought by Nicaragua to the International Court of Justice.